Good morning, everyone, and welcome to the launch of our online database, Mapping Civilian Harm, Claims Against Israel and the Palestinian Authority before Israeli Courts. My name is Yon Al-Kaisi, and I'm with Ceasefire Center for Civilian Rights. The database we're discussing today is a collaboration between Dr. Haim Abraham of UCL Faculty of Laws and Professor Gilat Bashar of Temple University of Law and Ceasefire Center for Civilian Rights. Over 470 Israeli court cases have been compiled and translated from Hebrew into Arabic and English for the first time for the period between 1955 and 2023. The interactive map presents Israeli court cases in which civilians sought compensation under tort law for loss of life, bodily injury, and property damage inflicted during armed activities. The vast majority of cases involve Palestinian civilians who were injured by Israeli security forces in the Gaza Strip and the West Bank. However, the database includes claims of other nationals, as well as cases in which Israeli civilians have sought compensation. But I'll leave Dr. Haim and Professor Gilat to get more into the details of the cases in the Q&A. The conception of this database falls right into our remit at Ceasefire. As an international initiative, we are committed to developing civilian-led monitoring of violations of international humanitarian law or human rights, to securing accountability and reparations for those violations, and to developing the practice of civilian rights. Through our programs and reports, we have worked in and on Iraq, Yemen, South Sudan, Syria, and other countries across the region. One example of our work is the opening of our legal help desk in Mosul, Iraq in 2021, helping civilians harmed by military operations navigate claims to uphold their right to reparations. However, the database we are here to discuss today is a collaborative effort, and as such, it gives me great pleasure to introduce our two panelists for the session. But first, I'd like to introduce Professor Eloise Scotford, Dean of the Law School.
Just in time. Hello, everybody. Welcome. I mean, my job is just to say welcome to Bentham House and to the Faculty of Laws. Wonderful. I have a couple of thoughts about this amazing project, but my main job is to say congratulations for getting to this point. Really incredible work. I know from working with Haim, who is one of my wonderful colleagues, how much work has gone into actually making this happen. There were moments where there were questions about how to bring this to life, which in academic research and academic life, there are often twists and turns, which normally involve finding money from someone to make something happen. And I have to say your ingenuity and persistence on making that piece of the puzzle has been very impressive. But I know this has also been a collaborative effort, not just on finding money. It genuinely has been a collaborative effort in the research that's gone on, the partnerships, but I think the spirit of this project is what is kind of most special and impressive about it. So I think the work that you've done as researchers, but also with your NGO partner, where's your research assistant? Is your research assistant here?
Yeah.
I mean, maybe you might be the most important person in the project. Very important people who kind of make things really happen. Obviously the funders. I think we've looked down every UCL sofa to see where we can get some money. But we have got UKRI, University of Haifa, Minerva Centre, coming forward to give a bit of support. We also have our amazing events team, Lisa Penfold, who always disappears, but she's pretty miraculous and means that we all end up in the right place. I nearly didn't end up in the right place, but that's because I haven't spoken to Lisa in time this morning. But me and John found her on the way here and she shepherded us in the right direction. I just want to say a couple of things about the database because it is super impressive. I'm an environmental lawyer, so this is not my domain, but I have taught tort law quite a lot. And it is hard to bring tort law to life. I remember as an undergraduate, I had a tort law lecturer who did bring tort law to life by telling us stories and drawing pictures on the board, and he told the personal stories behind the actions, which were normally involved car accidents and pictures of roads and things like that. But by and large, it is quite difficult to bring this doctrinal legal subject, certainly in this jurisdiction, in the tradition in which we tend to teach it, to life. This project is very notable for being something that brings tort law to life in quite an amazing, startling, confronting way. But you've done it with this kind of close database research, technology, which you're very good at. I'm very, very impressive. Lots of amazing infographics and things like that. But also the attention to personal story, to context, to the normative and social justice implications of the material that you're dealing with, the access to justice context, community reconciliation, these important kind of normative issues that are underlying and are very sensitive and difficult issues, but you bring that to understanding and presenting legal doctrine, because legal doctrine does always have big stories and big normative drivers under it, within it. And I think the way that you've done this is remarkable. I think the methodological story is really interesting behind the, and I think it'd be interesting to see what you talk about today. But you know, especially looking at the procedural kind of twists and turns of what's happening in these courts. And they do need to be kept in mind when you look at the pictures, because in a sense the pictures mask that a little bit. And I wonder what the reaction to the pictures will be potentially in that procedural story. I'm kind of interested to see what will happen there. But the other thing that I was really struck by, and I think about more as a dean level, and thinking about how different colleagues and research areas work together, the story of kind of legal interdisciplinarity here, the public international law story, the human rights story, the tort law story. These are worlds that don't necessarily talk to each other very often, as you know, Haim. Haim is one of the colleagues who gets pulled in many directions. And I say, Haim, you're pulled in too many directions. You need to, what's your center of gravity? And don't get pulled too much because you might break. But it's about bringing other people into that conversation, the international lawyers and who do more doctrinal research. Bridging those worlds is hard. But there is a question about how much kind of weight tort law in itself can carry. And I think that's I think that your research really asks that question. I look forward to next steps. Major achievement, well done. I'm going to sit here and enjoy the discussion for a bit, because that is, you know, with my kind of semi-tort law hat on, but I'm really interested. It's a fascinating project, and good luck with the discussion today.
Thank you. Thank you very much. And on that note, I'd like to introduce Dr. Haim Abraham. Dr. Haim is a lecturer in laws and co-chair of the Institute of Law, Politics and Philosophy. He holds a doctoral of juridical science degree from the University of Toronto, a Master of Law degree from the University of Cambridge, and a Bachelor of Law degree combined with the Interdisciplinary Honours Program in the Humanities from the Hebrew University of Jerusalem, where he was on the editorial board of the Israel Law Review. Prior to joining UCL Faculty of Laws in 2021, Dr. Abraham was a lecturer in law at the University of Essex School of Law. And before his return to academia, Dr. Abraham served as a law clerk at the Israel State Attorney Office, Civil Department. Dr. Abraham has organized several conferences, including Autonomy in Private Law, Past, Present, and Future, State Accountability Conference, Surrogacy in Israel Conference, and so on. In addition to his academic work, Dr. Abraham has consulted various ministries and non-governmental organizations in the areas of tort law, surrogacy, and parental status, such as the Ministry of Health of Israel and Israel's LGBT task force. So welcome, Dr. Haim.
Thank you very much.
Yes, and shall we do Gilad?
Yes, so Gilad is with us. Unfortunately, she can't be here presently, but she's with us in spirit and Zoom. Yes. And she'll join us for the Q&A session. You can all probably hear, so we can introduce her as well. Thank you.
And so joining us from the US is Professor Gilad Julie Bashar, who is an assistant professor of law at Temple University Beasley School of Law. She was previously a visiting professor assistant at Villanova University Charles Woodger School of Law, teaching contracts and dispute resolution. She was previously a research fellow with Stanford Center on the Legal Profession and a Stanford Law School postgraduate. Public Interest Fellow at the Center for Justice and Accountability in San Francisco, where she worked on social justice torts litigation in federal courts. So welcome, Gilad.
Hi, everybody. Thank you. Thanks for having me.
I'll
Right.
pass on to you.
Perfect. Thank you so much, Yom, and thank you, Dean Scotford, for these very, very kind words. And thank you, everyone, for joining us in person and online. I'm not going to say too much about how this project came to be. It's been a long time in the making. Both Gilad and myself independently started working on the topic of states' liability to compensate civilians in the context of warfare about 8 years ago. I was in Toronto, she was in Stanford, and we both started collecting data, conducting interviews, coding. And when we first got to learn about the fact that we were both in this topic, we were very excited. We kept talking about it. We kept thinking that we have to do something about it, but we actually never did. And it was only about 2 years ago when I had a meeting with Mark that we really started to think about how to bring this project into life, because we all agree that it's really important to bring these stories and to make these cases more accessible. And we all think that the idea of compensation in the context of warfare, specifically for individuals to be able to make these claims for compensation, is usually not receiving its adequate spotlight. Many times we have some focus on the law of war, and whether states are engaging in warfare lawfully and legally. Should we be able to prosecute all sorts of different war crimes? But one of the other reasons that compensation doesn't usually get any attention is because for many states, they have some form of an immunity. Usually it's a very wide, almost blanket immunity from liability for the losses that they inflict in the context of warfare. So it's very difficult for individuals to actually seek remedies for the losses that they sustain. And we want to bring back the focus to this topic because it raises two fundamental human rights concerns. One is about access to justice, and the other one is about the right to effective remedy. And we think that both of these rights should receive proper attention. And in doing so, we're able to provide more access to information that currently is only available to people who speak Hebrew and have membership for professional databases. So now this information is available in English and in Arabic for the public for free. Through this information, through this database, we're able to tell some stories, and it's not just the personal stories, they're broader stories that we'll able to hear from our panelists later, right? They connect to a broader political landscape, but it's important to do that while also providing a voice to people who usually don't get their cases heard. And in doing so, we're hoping to be able to advance transparency and accountability for these types of losses, while also providing some kind of tool for comparative research, provide legal authority on this topic that currently is lacking in the field. So why have we chosen Israel? I think you mentioned we have about 472 cases. And as you can see from the website, we have these. These are 472 decisions that have been made by Israeli civilian courts about in the context of compensation for civilians in the context of hostilities. These are decisions that have either been against Israel as a defendant or against the Palestinian Authority as a defendant. If we take a broader look at what exists in other common law jurisdictions, and we tally all of the cases in the UK, the US, Australia, and Canada, we have about 50 cases. So this database is really important in that sense. It provides a very rich environment to learn about how compensation works in the context of warfare. And I'm going to give you a very brief overview about how it works and what you might be able to find on it. So as you can see from the left side of the website, there is a timeline for the incident. These lines are going to represent the incident start date and the date by which the decision has been made. So there is some kind of visualization of the length of proceedings in general. It also, you can see that we have cases that are in orange and cases that are in purple. Orange cases are cases where Israel is a defendant. Purple cases are cases where the Palestinian Authority is a defendant. So you can straight away have some kind of visualization of where these incidents took place and who were the defendants in these cases. But because of the cluster, you can see that some of them are pinkish. So there's some kind of involvement, but you can zoom in and then they'll split back up. So that's one component, but also this is a map. It tells a story. It tells a story over time, and it's interesting to zoom out and see how it looks, not just because we have two interesting cases from the Sinai occupation, but one of the things that you can see if you want to see how the database works over time is that you can filter the relevant years that you might want to look at, but also when you actually play it, you start to see some kind of pattern. So there aren't many cases, very sporadic cases in the early years, but then starting in the first Intifada, especially during that time, there was an explosion of cases where Palestinians sought compensation against Israel. In the second Intifada, there are still a lot of cases, but you start to see two new things. One is that there is a change in the approach of courts and the legislator. Less and less cases are actually successful because the immunity has been expanded, and it has been expanded 3 times. And the other thing that you start to see is more and more cases that are being brought against the Palestinian Authority. So these are two very interesting trends that you can see here. You can also use all sorts of different filters to try and find other additional important information. So for example, if you just want to see claims by Palestinian plaintiffs, you can narrow down, see this is the vast majority of cases that we have, as opposed to Israeli cases. You can see that there are significantly less of those, and they're mostly against the Palestinian Authority. So that's one type of filtering that you can do. I think another important factor that this database provides is some insight into the way that the immunity from liability, the combatant activities exception, how it works. So here you can filter it and see all the cases where courts have ruled that it applies, vast majority of cases, as opposed to cases that it hasn't been discussed or was ruled not to apply. You can also use our search bar to locate particular types of keywords or any type of context that you're more interested in. So if, for example, you just want to see Supreme Court cases to see the leading precedent, you can just type that in. Hopefully it works, and I don't have a spelling mistake. Okay, so, and you can see that it filters down to just the key cases, and then you can start tracking and tracing the way in which these cases have developed. And over time, you can track the key cases. You can see how there has been a change in the sense that immunity from liability for Israel has been expanded, while at the same time, liability for the Palestinian Authority has been advanced. You have all of the data about the cases that's available here on this right-hand side, and includes both references, incident dates, decision dates, the result, a lot of various bits of information here. Our plan is to have the entire database available to download in English, Arabic, and Hebrew, so people can actually search additional data and filters that don't exist currently on the map. And it's very important for us to note that this project is ongoing. Cases are still being filed, a decision is still being made, and we're going to keep update them on a yearly basis as that comes about. And I think that I would like to finish by just providing a few small glimpses into the key findings that we have here. So, for example, we know that we have about 440 decisions where Israel was a defendant, as opposed to 32 decisions where the Palestinian Authority has been a defendant. We can see how over time these track. There has been this increase starting from the second intifada, but then with the expansion of the immunity, we can see that there are fewer and fewer cases that are being brought. This is because of a combination of much wider immunity and other procedural hurdles that are blocking Palestinian plaintiffs from the ability to actually bring these claims to court, something that doesn't exist for Israeli claimants. But I think that once you go further and look at the results of these decisions and how much compensation has been awarded, what is their success rate, you can also start seeing that something is quite different between claims against Israel and claims against the Palestinian Authority. In just 24 cases that have been successful against the Palestinian Authority, again, these are the vast majority of cases, there has been an award of almost 440 million Israeli shekels. This was mostly done through the award of punitive damages, which is something that generally is an outlier in tort liability in Israel and in many other jurisdictions as well. And you can see that we have 78 successful claims against Israel that have been awarded just 24 million shekels. This doesn't tell the entire story of how much money Israel has paid for Palestinians who have suffered various injuries. Israel has been paying various amounts of funds through settlement schemes that are not necessarily transparent. Those are not coded in our database. We don't have access to these particular claims. And it also paid compensation through military courts that, again, are not coded here. We don't have access to these. But we know that Israel paid roughly 350 million Israeli shekels through those schemes for about 2,000 cases between the years 1988 and 2014. So we can see a huge disparity between the number of these cases, how much on average every claim is being awarded for Palestinian plaintiffs as opposed to Israeli plaintiffs. And I think that it's also interesting to see that there's a difference in the way that different courts actually treat it. So these are different particular court districts. Some of these claims have been more successful in districts that are, I would think, more liberal or have a more diverse judicial profile, like Tel Aviv and Haifa and the north, as opposed to Jerusalem south and the center, which are fairly more hostile to these claims. And one of the motivations behind moving many of these claims, so they have to be argued in front of courts in Jerusalem or the south, was the fact that these courts are more favorable to Israel. And I think that the last thing I'll do, and I'll stop there and open up for Q&A for myself and Gilad, is that there currently is a new bill that has been tabled that is supposed to make things much easier for Israeli plaintiffs to claim compensation against the Palestinian Authority, and not only make it easier, but also that the sums of compensation are going to be much higher. So if now punitive damages are usually awarded around 3 million per plaintiff, they want to expand that. So it will be 5 million per injury, 10 million per death, all related to activities that are termed as supporting terrorist activities. So for example, if the Palestinian Authority had a speech where they supported an activity, or if they paid any kind of support payments to someone who is imprisoned by Israel, then that would be reason enough to find a way to bring a claim against the Palestinian Authority and seek compensation from that. So I'm going to stop there. And I thank you so much for taking the time to be here and look at our project. I'm going to go back to the map in case people want to have another look at it and have more questions, but I'm very happy to have a Q&A. I'm also noting that people online might have questions, so please note that you can put it up in the Q&A and we can bring those up here. But yeah, if anybody has any questions, we can bring a microphone for you to be able to ask questions and everyone will hear you. Thank you.
Thank you. Any questions? Yeah.
So 1 second, Marco, we're just going to bring you a microphone.
Thank you, Marco Longobardo. I have a very stupid question, but this is fascinating. I didn't know there were cases brought before Israeli court against the Palestinian Authority. So never had heard about this. So what about any potential claim of sovereignty immunity by the Palestinian Authority? How do Israeli courts treat this? I know it's a very legal question, not related to the project. That's amazing, but it just came to my mind. You can say just 2 words, or we chat about this later. Thanks and congratulations.
Perfect. Thank you so much, Marco. No, this is a really great question and it really ties it in well, right? So we can see that the combatant activities exception is not really a part of the sovereign immunity doctrine in that particular way, but it's related to it. So the idea of this particular immunity is that states operating in their capacity should not be liable for these particular losses. There are all sorts of various shady explanations that are not sufficiently theoretically developed. To learn more about that, see my forthcoming book. But the particular point about Palestinian Authority claiming sovereign immunity, they've tried it. They've tried it several times and they keep failing. So Israel is doing something quite interesting. It's picking and choosing when it's treating the Palestinian Authority as a sovereign state. And in the context of tort liability and compensation claims, it's saying that it's not a sovereign state, that it shouldn't enjoy sovereign immunity, that it shouldn't have any kind of active state doctrine that will be applicable to it, but also that it shouldn't enjoy the combatant activities exception. So in Israel, the combatant activities exception is framed in a sense by referring to a state, and courts have rejected the idea that the Palestinian Authority can be considered a state for the combatant activities exception purposes. And of course, that terrorist activities are not considered combatant activities. That was another point about the way in which that exception doesn't apply. So we can see that it doesn't enjoy any type of these kind of procedural immunities that would otherwise exist. Thank you.
Any other questions? Or maybe something from online?
Perfect. So I see a question online. I'm going to answer it. And the question is, where can I look for the relevant cases database? Perfect. Thank you very much for this question. So the website appears here at the top of the bar. We're also going to make it public afterwards in our emails. It's civilian harm map at ceasefire.org. The cases themselves, you can see them on the map. So you can either use the map to click and choose a case, or you can just use this right-hand bar to go through these cases and get additional information. So for example, if you're interested about this case, you just click it, you open up, and you see incident date, decision date, the result, whether costs have been awarded, whether compensation has been awarded, who was the judge, gender, age, nationality, the court, the cause of action, the defendant, and a short case summary that gives you the facts and what the court has held, so what the court found. So that's one way of doing that. And of course, you can find more information if you decide to filter things down, right? So for example, if you just click on these, it will just open up these two cases that are clustered here. If you pick something else, it will give you these cases that are clustered here. So you can just go about and play with that a little bit. And then the database itself as a whole, what we hope will be available to download, and we'll update that. It will be in one of these tabs, probably under the civilian harm tab. Yes.
Hi, yeah, thank you so much. I think it's really fascinating. So I have a few questions, sorry. Firstly, are we to understand that this is exhaustive as much as possible, or are there cases that, you know, that the documentation still remains like unreleased or is not available, etc.? Secondly, on the PA thing, do they actually take the money when the PA is, do they do it, you know, like they do with other punitive things where they just take it from the PA tax revenues? Is it, or do these compensation claims get paid? And then I wondered if you could talk, so I thought you talked interestingly about trends over time, like if you could talk very specifically about Palestinian claims. Could you notice trends in terms of internally within the claims about when they are more likely or less likely to be granted? So is it, you know, not over time, but is it like if they're more likely that the case relates to, you know, something, you know, like for example, we've seen with US compensation claims that they're actually sometimes more likely to accept it when it's, you know, they've blown up a shed or they've killed some some animals, but maybe less it's likely to accept it when it comes to civilians. You know, obviously this is civilian harm specifically, but like, is there trends within those cases as well that you could talk to?
Perfect, thank you very much. So let me take these questions in order. Is this database exhaustive? It's as exhaustive as we could probably find the cases. So we used the two biggest commercial databases that are aggregating all of the cases. We've used some additional research going to actual courts and finding more data as much as we can. We've also extrapolated data that we could extrapolate that is not otherwise available, but is referred to in court cases. That's a very low amount of cases that we found in that way. So this is all that we could find. Now, it's not everything necessarily that exists, especially in terms of the way in which many of these claims have settled outside of court. So there is no record other than a Freedom of Information Act that disclosed the fact that these cases exist, and generally the amount of compensation that was awarded per year. So I have these emails here with me, and we can talk about that a bit more if you want, but those are not otherwise publicly available. And there's very little data on military courts and compensation. So that's not coded here as well, right? So this is just Israeli civilian court cases that we could find from the publicly available databases. So that much is in terms of the way it's exhausted. About the Palestinian Authority and what happens when there's a ruling against it, whether plaintiffs can actually claim the compensation. That's a really interesting question and very tricky. I've tried to speak with a few of the lawyers who represented plaintiffs against the Palestinian Authority, and they've said that every now and then they've managed to claim something, but by and large, these claims have not been enforced or paid. So the vast amounts of compensation are probably currently just standing there as big vanity checks, which is a problem, right? Because when the plaintiffs really want to pursue it, and they have the resources to do that, they can try and find ways to enforce their compensation in other jurisdictions or even within Israel. But by and large, there's a problem with the enforcement of these amounts, especially due to their huge size. And that's a problem that we can also see in other jurisdictions, like in the US. So the US has a special bit of legislation that allows courts to impose punitive damages on foreign states, and they've done so against Syria and Iraq and Afghanistan. And plaintiffs just don't have a way to recover. They just have these huge amounts that have been ordered in their favor. So that's a problem. And about trends over time, the clearest trends are that liability has been limited time and again against Israel. And it doesn't really matter in this context whether it was bodily injury or property damage or death. Those are all being ruled out, bundled together in the same kind of context. I think that at least in the early years, you could see that there was slightly greater capability or greater reception to awarding compensation when you have people who were clearly uninvolved in any type of activities against Israel and were just collateral damage. So there have been instances like that that were more prevalent at the time, but now, because the exception has expanded to include not just actual combatant activities, but also policing activities, counter-terrorism activities. So if somebody is being arrested, or if somebody's at a checkpoint and they fear for, and the soldier fears for their lives and they decide to open fire, that's going to be included as well, even if that fear is not substantiated at all. So I don't think that we can see any kind of trends in that sense. And unfortunately, we don't have any data on the settlements themselves, so we don't know if there was anything that's being done in the background.
If I can add just anecdotally about the settlements, while we don't have concrete data, as Chaim mentioned, we do have a lot of data from interviews with the majority of lawyers, plaintiffs' lawyers that have represented Palestinian plaintiffs in these claims over the years. And so their accounts show that you can definitely see a trend on the settlement side as well. So you can see previously, the state of Israel was willing to settle in many cases. And so even more settlements than what we see in the cases that ended up with a court decision. But then over time, the willingness decreased. And of course, that's also related to the legislative climate, right? As Chaim mentioned, as we see the legislation becoming more and more hostile towards these claims, that affects the settlements as well.
Thank you, Gila. I think maybe we'll take one more question online and then wrap up this session. This question is from Elena Moresi. How do you think the map will look 5 years from now or sooner?
Perfect. Thank you very much, Elena. So I think that 5 years from now, we're probably going to continue seeing maybe a handful of cases against Israel a year. Because the immunity has been constantly being expanded. But we're probably going to see more and more claims against the Palestinian Authority. Maybe not in the same amount as we have seen before, but it's going to still be here. It's going to be constant, and it's probably going to continue being very different to what we see from claims against Israel. It's going to be bigger sums of compensation. It's going to be very lax about its rules. It's probably not going to go anywhere. So how will this map look like? It's going to be a lot more pink in the future, with a lot more things that happen outside of the West Bank and the Gaza Strip and happen more in Israel. I think that's how it's probably going to look like. I know that we have still a few more questions online and in the audience, and we'll have another chance to have another Q&A after the main panel. But if we have time for another question, let me know. I feel like I'm not in charge of my own time.
We're just
Bang on time, excellent. So apologies for everyone, we haven't managed to quite get to their questions yet, but we will get to them after our next panel.
brilliant. Thank you
Thanks.
so much, Chaim and Gilad. Thank you for your question. So
Hi, Gilad, are you still with us?
Yes, I'm here.
You able to stay for the next? You able to stay for the next hour?
Yes, definitely. I'll be here.
Okay,
Sorry
okay.
again for not being there in person with you.
That's all right. So I don't actually have any IT in front of me. So if you want to speak or if you want to do that, you're going to have to be assertive and say something so I can hear you.
Okay, I'm good at that.
Okay, great. And while we're waiting just for everyone to settle down here, I just wanted to ask you one more question, which was that but both you and Chaim have talked about these trends over time. I just wanted to ask you about the moment you first started looking into this and whether you were surprised by what you found.
Yes, absolutely. I remember that moment well because I was clerking for the Israeli Chief Justice at the Israeli Supreme Court. And we were actually handling an administrative case. But that was a family of a 9-year-old girl, a Palestinian girl, who was fatally wounded by an object. It wasn't clear whether that was a stone or a rubber bullet. But the investigation had so many flaws, and it was on the police that investigated was unable to find who was responsible for this little girl's death. And I was so struck by that case. It moved me so much, and the justices were too. But the administrative process, though they tried to do something through that process, it was unsuccessful, because the investigation was just so flawed in the first place. But then I realized that alongside that administrative process against the police, there was actually a civil claim going on, where the family, the parents of that little girl could actually go before the Israeli courts and bring a claim to really vindicate their child's death and get their day in court and be heard. Of course, that wasn't, going to bring their little girl back to life, but having the ability to have that ownership to actually bring the claim themselves was striking for me. And I realized that this was not the only claim, and that many others have been bringing these claims, not many successfully, but there were definitely these cases. But the public is not aware of it, and even among the legal community, there's very little awareness of these claims. So I started kind of investigating. I was surprised by the number, just the sheer number of cases that have been brought over the years, and started thinking that, an empirical project, actually getting all the data and speaking to the relevant people that have handled these cases over the years, people like Sausan Zahar that we're so lucky to have today, that would be the way to sort of get a glimpse into these cases, even though so little attention has been given to them over the years, and to really give voice to the people, to the plaintiffs who were involved in these claims over the years, and the lawyers that represented them. Thank you for asking, and I look forward to hearing from this great panel.
Thank you very much, Professor Rochelle. So my name is Mark Latimer. I'm also from Ceasefire. And I just wanted to start by picking up on a couple of things that were mentioned already over the last hour. Chaim talked about the right to a remedy, which sounds like a rather boring legal thing, but it is absolutely fundamental when we are talking about both human rights and the laws of armed conflict. Every human rights treaty, every single human rights treaty has as one of the rights, the right to a remedy, because there's no use in having a right to life, or a right not to be tortured, or a right to health or to education if if that right is violated, you have no recourse. Therefore, the whole of the human rights system is anchored on this question of the right to a remedy and reparation. And that is why projects like this, which we're very pleased to be part of, are so important, because they actually show, they demonstrate whether that right to reparation or to a remedy for the violation has been upheld. Most states have a mixed record, and I think it's important to consider the record of Israel in the context of what has been done in other states, in other places. This session, therefore, is called Contextualizing the Human Rights Claims Before Israeli Courts. And for me, that contextualization consists of maybe two things. The first thing is to contextualize or to place the civilian harm claims before Israeli courts in the context of the wider Israel-Palestine conflict. Dean Socotra said this morning, can tort law bear the weight of the violations or the weight of the responsibility for making good those violations? I think that's a really fundamental question, and one that is raised by all the information that we are presenting to you. Is it enough? Are those individual claims enough, even if they are dealt with fairly, even if there is better access to justice? We have to look as well at wider issues, not just legal ones, but political ones in the context of Israel-Palestine, and also, of course, at other potential legal avenues, including ones that some of you may be well aware of that are taking place at the international level at the moment. So that's the first big part of contextualization. But for the second one, I think it's also interesting or necessary to look at the record of the Israeli courts on upholding the right to reparation for violations of human rights or international humanitarian law, beside the record of other states. Those of you who have followed our work at Ceasefire will know that we are also looking at the record of the UK, the US, Iraq, the Syrian authorities, Yemeni authorities, many different states in trying to encounter this question of how violations of rights in situations of armed conflict are dealt with. So no two situations, I always say no two situations are the same. Every armed conflict is unique in its specificity, but we can learn from looking at what other countries have done, including this country that we're sitting in now, including the United Kingdom, which of course was the occupying power in southern Iraq for some 8 years after 2003. What has the UK done in terms of compensating or offering reparations to Iraqi civilians who have been killed in the course of its armed activities in Iraq? Big questions. We've got a very expert panel to debate some of these questions. I'm going to introduce them in turn and just ask them just to say a few words quite briefly for 5 minutes, so that we have lots of time for question and answer a bit later on. So first of all, I'm very pleased to introduce Sorsan Zaher, who is an advocate. She was formerly Deputy Director of Adala, the Legal Center for Arab Minority Rights in Israel. She has specialized in taking constitutional cases, including ones that have set important precedents before the Israeli courts, including the Supreme Court of Israel. So I'm very pleased to talk, to introduce her, to talk about what it feels like to take Palestinian cases before the Israeli court.
Well, good morning, good afternoon, everyone. Haim and Gilat and all Ceasefire team. First of all, I must say that really I give you all the respect for this amazing project. The map is a lot more than I really thought it would include, and Yishar Koach for all this work. So thank you, Mark. I think this is a very interesting question, because it's not just a professional question of how does a regular lawyer feel when we approach the Supreme Court or any other court when we are dealing with human rights, but it's a very personal issue. It's an issue of politics of identity that play a huge role when you want to litigate and argue constitutional issues. It's sometimes the mixture of how the judge looks at you and how they approach you, especially the conservative judges when they approach in questions or they want to confront or challenge an argument. And sometimes there is you can feel that there is no a disconnection between you as the professional lawyer and you as the Palestinian person who is standing before the court, especially in cases that are very political or that are very sensitive in terms of dealing with issues that are related to security or so-called terror. And one of the things, one of the cases is basically this case. This case where I mean litigating and arguing before the Israeli Supreme Court against the constitutionality of a law that was enacted in 2012. And you let me know when you want me to stop, because I can start speaking about the litigation and never stop. So the law, and it's very relevant, of course, to the to our event here. In 2012, Israel, the Knesset, the parliament, basically confirmed a law that prohibited any of the Gazan Palestinian residents from submitting tort lawsuits before any court in Israel, claiming that all Gaza residents are enemy aliens. And therefore, as a part or as a purpose to try to combat and challenge any kind of financial support for the enemy in order so that they will not pursue any kind of security or so-called terror attack, Israel passed this law. But this is an example of how the law is being engineered and designed as another way of a political tool as part of the larger picture, being in a state of a war, whether it's a war against a state or a war against non-state actors or against, in this case, against Palestine. And it's very interesting here as well, what Chaim said, that Israel sometimes chooses to deal with the Palestinian Authority as sovereign, and sometimes it basically argues that there is no sovereign and that there's no one basically in charge, either regarding the West Bank or regarding Gaza. And of course, no one talks from the Israeli sides about Jerusalem because it has been annexed in contrast to international law. So what I'm trying to say here is that also this was not the first law that was brought, which I litigated this one when I was in Adala, banning Gazans from approaching the court in order to seek effective remedy based on the right in international law was not the first law. This was basically the continuation or follow-up of a more holistic design of set of laws that Israel started already in the beginning of the Intifada. In the early 2000s, it expanded the definition of war acts in order to apply them on as much possible acts that are related or resulted from the Israeli army and in the West Bank and the Gaza. In 2005, it confirmed and passed a law that basically banned residents in the West Bank from approaching the Israeli courts for tort cases for damages resulted by the Israeli army, and Adala submitted immediately a petition against this first law. It was called Amendment number 7 for the Civil Wrongs Act from the 1950s. And the Supreme Court back then in 2006 saw it right to accept the petition and cancel the law. And this enabled the West Bankers to continue approach the law. But in 2012, the case that I mentioned before that I litigated in regards to Gaza was basically, okay, we gave the West Bankers the ability to approach the court, but we want to close any kind of option and any kind of not only a door, but an open window for Gaza residents to approach the Israeli courts in general. And this is part of the continuation blockade. So blockade is not just closing Gaza from entering and exiting. It's not just limiting the amount of food and essential products. It's also basically closing and prohibiting people from seeking damages for damages that resulted from the army. Now, what is the purpose of all this design, of all this engineering of a whole legal system? It's basically in the core essence of the Israel concept of providing full impunity to any kind of soldier, no matter what rank they are, whether they are commanders or ministers or even regular soldiers that go on the ground and result the tangible damage, and also providing full accountability to anyone, no matter what. Now, these set of laws and using the law for the purpose of providing accountability is the thing that provides the answer to the phenomena that we saw in the map. Why we have gaps in the number of in the amount of money that are being paid, because there is a set of law that prohibits Palestinians not only from like it is now limited only for the West Bankers. Otherwise, we would have seen a larger number in terms of lawsuits, in terms of money, but the laws have been confirmed in order to serve the lack of accountability and gives an answer basically to all the numbers in the map. Sorry for that.
Thank you very much, Sorsan. And we're going to come back to you in many times. So,
yes.
So you can enjoy your cup of coffee. So the situation in terms of legal obstacles for Palestinians, particularly from Gaza, but also from the West Bank, to access the Israeli court has got worse over time. But it's important also to look at other factors, other trends in both how complaints are dealt with, how issues not just of violence by Israeli security forces, but also settlers is dealt with. And I'm very pleased to have with us this morning to talk about some of these things, someone who has, I'd say, unique insight, having lived in the West Bank and Gaza for about 30 years, reported for Haaretz and other outlets. She's an award-winning Israeli journalist and author, Amira Haas. And she has, in particular, been able to report on the situation, as I say, in both Gaza and the West Bank over a significant period of time, So I wanted to introduce her, to say a few words, and to give us an insight into whether over that time things have changed, or whether she has seen particular trends in how Israel has dealt with claims for civilian harm. Amira.
Thank you. Thank you. First, I want to second Sausan in congratulating you for this map. I think you add, or you help us all who want to conceptualize the characteristics of Israeli policies and Israeli, if I may say so, nature. You have helped us a great deal. I think you, in this very attractive or fascinating map, you encapsulate Israeli forms or Israeli almost unmeasurable capability of controlling Palestinian lives and everyday management, the freedom to take money. If Israel has not yet taken money off the customs, it might do so very, very easily, as it does with so many other issues. When they want to take money, they do take money. Now they deduct the money from the Palestinian customs that they have to transfer. They deduct money that is equivalent to the money that Palestinians pay as allowances to Palestinian prisoners' families. So they have the freedom to do it if they want. And I'm afraid that now with the new government, and if they hear you or know about the map, they will probably do it. I think that this map also, you know, in a nutshell, says that the term double standards is an understatement when it comes to Israel. There are so many. It's so annoying that I don't even have the words to describe my annoyance. And you know, as I'm not from the legal field at all, and with the years I find myself more and more at loss vis-a-vis this vocabulary, legal vocabulary. I think you do it in a very good way. Also, what you drew attention to is this policy of pick and choose. And this pick and choose policy probably has always been there, but I see it especially growing and consolidating after the signing of the Oslo Agreement. Because actually what Oslo enabled Israel, what the Oslo Accords have enabled Israel, is to completely dissociate itself from its obligations as an occupier. Before Oslo, Israel somehow acknowledged its being an occupier. And that's why we know that soldiers knew that they had to be careful with harming Palestinians' lives. They had to be careful because there was an automatic investigation. There was an automatic, there were cases, and I remember that still in the 90s, I was covering, it was all new to me, but I was still covering some cases of lawsuits filed against the Israeli army for casualties. And it was very clear that the army has to be careful. Now it doesn't exist because there are no such obligations as an occupier. And we see it in all through the way. Now you talk about casualties and indemnities for loss of life or injuries, but Israeli policies is much beyond is much more than the danger to people's lives, and not much more, but it encompasses so many more aspects that invade into people's normal life and make it totally abnormal all the time. For example, is there a way to file a lawsuit against the Israeli, what I see one of the main policies of robbery of time? Israel robs Palestinian time all the time. Every aspect from birth to death,
Israel for very, very simple issues, issuing a birth certificate, going to the hospital, going to the grandmother, buying grocery. Everything is involved with an extra loss of time, not loss of time because of traffic jams, modern traffic jams, but because of a very evil Israeli bureaucracy that doesn't allow Palestinians to own their time, and nothing to do with war confrontations. No, in civilian time, in normal civilian life, Israel does not allow Palestinians to have water in the great part of the West Bank, and also in a way in Gaza. So has there been any lawsuit about this? No. So this is me and the non-legal person. I'm asking, no, this is lacking. It shows that what has reached the courts in Israel is just a drop in the ocean of Israeli attacks against Palestinians' lives. Look, the law, as was said here, the law and the legal language, and especially for me as a total ignorant laywoman in these terms, is a shield, or is another shield, is another customs that camouflages the fact that if I want to summarize Israeli policies, is the policies of a settler colonial entity against the indigenous people. This is the reality. So whatever legal terms or legal robe that they want to put on it, for me, it's less important. But as a settler colonial entity, the life of Palestinians, the indigenous people is redundant. At any moment, this settler colonial entity will find way to make it disappear. So if not disappear from life itself, but from the map, from people's attention, from road signs in the West Bank and in Israel, from history books. So it is redundant. And I think this is for me the main issue when I look at Israelis, when I say double standards, who's double standards? I mean, Palestinians don't exist, so it's not even double. One of the main things that we see a deterioration here or escalation is, of course, it comes to the issue of attacks by Israeli civilians or Israeli settlers against Palestinians. And this has been also before Oslo, before the Oslo Accords. We already know that in the early 80s, there was a special commission that was formed in the Ministry of Justice to discuss cases, and not that many as like today, but still very alarming cases of Israeli violence, settlers' violence against Palestinians. And it was following a letter by law professors at Tel Aviv and Jerusalem University expressing their worry, their concern that this lack of Israeli absence of Israeli or inexistent treatment of Israeli violence, settlers' violence, is very dangerous for the future. And there was a report by the head of the committee, commission or committee, Judith Karp, and she writes things that would resonate today as if they were written today. Only that back then there were many less cases, and the law professors were interested in it. Today, we don't hear law professors in Israel who are expressing their open alarm about Israeli settlers' violence. The second thing is that the Israeli settlers' violence, while in the 70s and 80s could be very murderous and of course very, very aggressive and very often around Hebron area, in the Hebron area, it had to do with individuals and with a sense of revenge against Palestinians. Since the mid-90s, it is a deliberated, calculated, planned violence that aims at grabbing more and more land from Palestinians in the area called Area C, which is under full Israeli military control. So it is geared at getting more, at forcing Palestinians to give up their land, to stop going and work their land, or go as shepherds with their sheep, because it is too frightening, and because the settlers are attacking and are totally enjoy total impunity. This is the West Bank is maybe one of the areas most covered by surveillance, all kinds of surveillance gadgets and facilities. So there is no problem for the Israeli authorities to locate somebody who went out of an Israeli outpost, illegal, unauthorized outpost, and went to set fire or to beat a Palestinian shepherd. There is no problem, and they are never being caught. About 91% of the cases of the complaints about attacks, the files were closed down or ended without any culprit to be found, because they don't look for them, because it is part of the Israeli policy of getting more land. How Israeli settlers' violence is effective, we only saw in the last two months, 3 Palestinian Bedouin communities of around 200 people each had just pack their stuff, pack their meager belongings, their sheep, and their put them in the vans and went somewhere else in Area B, which is under Palestinian civilian authority. They couldn't stand anymore those settlers' violence. This continues and continues. We have, from the beginning of the year, we have a rate of about 5 attacks, an average of 5 attacks per day. 95 attacks, 95 attacks per month since the beginning of the year. And this is a constant and steady escalation that we can only thank the Israeli law and order authorities for, because they are totally idle about it.
Thank you very much, Amira. So I started off talking about the right to reparation and the importance of having access to a court. And that's something that the work of ceasefire is centered on. But listening to you, Amira, there's this alternative vision, which is that, which is almost as if the law really is just a gloss, or it's just a pretense, that it doesn't really have any meaningful effect in trying to deliver reparations, because of the realities on the ground are sufficiently grim that either there is no access to law, or that the rule of law itself is something of a sham. To try and unpack that question, I'm pleased that we have Seth Amziska with us, who is at home, in fact, who's a professor here at University College London, professor of Jewish-Muslim relations and founding director of the Middle East Research Center. Seth is the author of a really important, really illuminating book called Preventing Palestine, which looks at the political history from Camp David to the Oslo Agreement. And I know that he's also been responsible for uncovering some fairly alarming source material relating to the 1982 Lebanon war. He's published widely, including in the media. So, Seth, try and talk to us about some of the wider legal political questions and how they interrelate.
Great. Well, thank you, Mark, for the introduction. And really, let me add to the compliments that both Salson and Amira have given Chaim and Gilad about the work that's gone into this database. I mean, I'm here as an interloper, as a historian, but we love our data and our archival materials. So to have this repository of information publicly available in Arabic and Hebrew and English is enormously important as a way we can think and write critical legal history, but also wider critical political history. which is, you know, the stuff of the work that needs to be done to try and unearth and explain the genealogy of how we've arrived in this current moment that I think Amir and Safsan also both just pointed to. What I wanted to briefly maybe sketch out, I think it might be useful, is to think a little bit about where this fits in the wider story of the Palestinian question or Israel's relationship to the Palestinian question, particularly since 1967. But I also want to be mindful that that's a danger to slip into that idea that this is just a post-67 story. And there's a great deal of scholarship that would actually have to go back to the question of 1948 and what legal responsibilities the Israeli state has towards Palestinians, not only politically and morally and ethically, but also in terms of property compensation, in terms of crimes. For example, you think about the Tantura massacre. There's been an interesting discussion about this recently in a new documentary film. But I'm going to set it aside or bracket it, not to lose sight of that, but think a little bit about responsibilities around the dispossession of Palestinians in 48 and the Nakba, and how that has fed into or illuminated decisions around legal consequences. But I want to perhaps specifically talk about what happens with the conquest of the West Bank and the Gaza Strip and the Golan Heights in East Jerusalem in 67, because initially the attitude of the Eshkol government, and we know this from really interesting historical work done by Avi Raz and others, is to try and take as much of the dowry without taking the bride. So the idea of property or land acquisition without the population, the fear always of the demographic parity that might be reached between Jews and Arabs, between the river and the sea. This was a kind of guiding principle in how the Israeli governments viewed these conquests, but always a decision since the Eshkol government, as Raz correctly, I think, points out, a decision not to decide on the fate of the territory. So you hold these territories in a kind of state of non-annexation and non-return. And I think this theme is actually the thing that gets us to where we are, even in this database, is that you don't treat the population as occupied civilians, and you don't treat them as people resisting and deserving of rights in political terms. That non-determinate outcome is probably now, I think, actually being challenged with a form of de facto and de jure annexation today in 2023. But I want us to think a little bit about that arc. One thing just to say from the legal perspective is the original legal revolution, it's not happening today. The original legal revolution is discounting the decisions of people like Theodore Meron, who was the advisor to the foreign ministry, who was very clear about the conclusion that civilian, and I'm reading from his decision in a top secret memo after 67, my conclusion is that civilian settlement in the administered territories contravenes the explicit provisions of the Fourth Geneva Convention. So clearly, from a legal perspective, it was very much understood in the Israeli political establishment what the implications would be of this conquest. I think one could say that you can sketch the early years as a moment of time of both kind of dismissing or getting around that, mostly through a process of saying that Nahal or military units could be used instead of civilian outposts to create these greater settlements. But you ended up in a situation by the mid-70s where perhaps you saw these residents, these Palestinians, as a minority, not necessarily deserving of rights, but you never saw them as a population deserving of any collective form of political sovereignty. By the late 70s, I think the calculus changed, and I think one of the reasons that is because of the use of violence and armed resistance, and a kind of moment of PLO attacks and the suppression that followed. So a kind of move to begin to look at Palestinians as a threat in the context of the 70s and 80s is what I work on how sovereignty is prevented politically through the Camp David Accords and the Lebanon War. But one of the most interesting, if any of you are movie buffs of Amos Gitai, if you take a look at his short film Yoman Sadeh, Field Diary in 1982, you see the state of affairs in the West Bank right on the eve of the Lebanon War, and you see how the Israeli government and military was looking at Palestinians in that period. What begins to change, and I think here Amir is correct, not only at Oslo, but before Oslo, is beginning to see the recognition that maybe territorial partition, and this is a brief window in the late 80s and 90s, and the right to some form of territorial entity for Palestinians needs to be considered. And this is, in a way, the innovation of Rabin. I want to be very careful not to talk about this as the idea of a state, because it's not a belief in a state, it's a belief in some kind of autonomous entity. But there is a moment in time when the Israeli political establishment is beginning to think about that. And that obviously leads to a huge amount of backlash, of resistance against that idea. But the Oslo process, which is supposed to lead to that potential outcome of some form of political sovereignty, also leads to the creation of the Palestinian Authority, which becomes almost the shock absorber of the particular claims of these Palestinian residents now in the West Bank and Gaza Strip. So rather than these individuals being able to bring particular claims against whatever is happening to them, the PA, and I think you see this from actually the map that Chaim and Gilad have put together, the PA becomes a kind of middle ground which absorbs many of the friction between the state and the occupied population. The penultimate period maybe to talk about is really from the Second Intifada in early 2000 until maybe 2016, 2017, where what you begin to see is a move away from the idea of that partitionist model, but towards something of a separation, not a separation for the sake of political outcomes of rights, but what Dov Weissglass very famously said in the separation or the unilateral withdrawal from Gaza, a process of formaldehyde. You freeze Palestinian political claims through retrenchment, through territorial separation, us here, them there, and you can freeze the political process into a condition of neither two states nor one. And it's that liminal space where I think the grounds for what we're seeing now come about, which is really a process of concentrated political, certainly in the case of what Amira described, of expulsions and of movements of communities outside of where they exist, a kind of concentration into areas B and elsewhere, but also a process of de facto and de jure annexation. And so what you see from figures like Itamar Ben-Gvir and Bezalel Smotrich is where, you know, the marginal position of the settler movement, the vanguard that was resisting the state's legal thinking or political thinking about non-annexation, they have moved to the center. And so we are now in a position where they are in control of the apparatus of the state, but also of the very realities of what's happening on the ground. And this is where you get things like the pogrom in Hawara, and where you will see more of this continuing to happen, because the violence that can be exacted upon Palestinians can happen without any real consequence. Nobody's really going to do anything in that in that context, which leads me to my final point, which is then interesting to think about how the law and legal cases map onto all of this political history. Because what could be interesting to think about in terms of the work in the database is, when do the cases rise and when do the cases fall? What role does the Palestinian Authority play as a shock absorber in the story? And to what extent does the law, I think, facilitate the process that I'm describing of state prevention and the deprivation of rights, rather than thinking about the law as a space where you can actually advocate for further rights, so that the law becomes the mode where for so many years it's actually enabling this kind of behavior. And that actually, in a way, brings me back to the first point I mentioned about Theodore Meron, is that if a legal counsel of the Foreign Ministry is deploying the law in the initial aftermath of the acquisition of these territories and saying that these are contravening the Fourth Geneva Convention, and that is disregarded by the very state that's employing him, well, what then role is the law today? We can talk about tort, we can talk about individual cases, but I do think we have to consider what the legal lens is doing here in avoiding some kind of political responsibility. And it's why so many human rights organizations like B'Tselem and others have abandoned the legal route in the Israeli context, and why there's a lot of skepticism, in particular, even around the protest movements today, and this idea of the judicial revolution, because anybody who's been following the story from the vantage point of Palestinian claim making is telling you, well, what is law under apartheid? And I think that's where the conversation is at now.
Right, thank you very much, Seth. So I'll open it up for questions and answers. We still have Gilad with us, and maybe can I invite Chaim to come and join us? So when the questions get really difficult about the database and I can't answer them, I can just look to Chaim and Gilad, the other side, I think, yeah. While you're doing that, I was just to react to the last thing we heard. It's interesting that the reaction of the Israeli Foreign Service or the legal service to that process, that discussion, and the Meron memo about the Fourth Geneva Convention, was to now have a settled position that the Fourth Geneva Convention does not apply to the occupied Palestinian territory, and that has been their settled position for some decades now. That is not agreed by most of the UN authorities who have looked at it. But so the reaction to, if you do this, you'll break the law, is to say that law does not apply to us. Questions, comments, reactions? Right, yes. So maybe right at the back, please. It'd be quite useful for us, I think, if you just mention who you are.
Yes, I'm Yuval Shani from Hebrew U, and I want to join the previous speakers in congratulating Chaim and Gilad for this and ceasefire for this very important project and resource. I wanted to. It's really not well. It's the cliche of not another question, but a comment. But I did want just on the. I think on Seth's comments, I do want to say something in favor of accepting the limits of law. I mean, I think it is. I think one has to be wary of jumping from into a conclusion that says because we do not accept the general framework, and of course Israel never accepted the general framework, then law cannot serve any purpose in restraining governmental power or in providing some remedies to some victims. And I think actually the numbers are interesting in the sense that they do say that they do, I think, force us to consider what's the value of 20 or 30% of a success rate in a context where you have a lot of injustice around you and the very contours are extremely problematic. Is it still, I mean, certainly from a practitioner's point of view, for an individual, I mean, being on the right side of the 20 or 30%, of course, makes the whole difference in the world. So I just wanted to perhaps encourage that we address this. I would be somewhat reluctant to draw a direct line from the rejection of Meron's opinion to basically saying, well, everything has been, a charade or a sham. And I think that the moment that we are in time now, and I think that's a very, I associate myself with this observation, is really an attempt by the camp within Israel that saw this 20 or 30% actually as a national disgrace, or it's basically the poor man's lambs who is now up for slaughter. And I think that this is what's currently at stake in Israel. So that's my short comment. Thank you.
Thank you very much. And we'll pick up a couple of other questions. So I think Dr. Abu Harab, yes.
Rod Abu Harab, I'm in political science at UCL, so thank you for this. I guess I'm just thinking about, some of these questions from a sort of a political science perspective. And one of the things that really, or two of the things that really kind of struck me about this discussion so far is if we're thinking about, the dynamics of violence taking place here, right? So you have state and non-state actors who are committing violence with very little accountability. And in political science, we would tend to think of that as a really strong predictor of more violence, civil war, and not something that is going to decrease the level of violence taking place, right? I mean, so there are some arguments around this, but if you face overwhelming force, do you then give in? But in most of these models, it seems to be one that actually leads to more and not less violence, right? So even from a self-interested right-wing Israeli perspective, do I really want to be in that much violence as a state? That's just one sort of question comment. And then I'm thinking about kind of, so, Israeli partner states, so thinking about kind of external pressure. Is there any leverage for external pressure to change these laws, to actually make people accountable? I'll leave it there. Thank you.
Thank you very much. So I think we'll take those, and I sense that Amira might help us with starting off.
Look, if I look at this pattern that is consistent for so many years, then my only conclusion is that yes, this is the aim. Because the least I can say about Israeli governments is or Israeli politicians, that they are stupid. They're not stupid. And they are very versed in history and in psychology, whatever. You have experts, psychological experts that are being sent by Hamas, by Shabak to the prisons to speak with prisoners. So they have experts for everything. I tend to believe that just as the non-state violence is planned and organized, so is the blind eye is planned and intentionalized. It might be, they might think that Palestinians will react differently to violence and will accommodate themselves. But I'm afraid that the more extreme right wing, which has become much more, which has moved much more to the center. I mean, not because it is centrist, but because the center has moved to the right wing. I do think that they see as prospect as a possible. No, I don't think so. I know because Smotrich has said it in so many words. They hope for mass Palestinian emigration, to be polite, which means expulsion, mass expulsion, new mass expulsion in the magnitude of 1948 is completely tangible for them, and they are aiming at it. Actually, this has been what the process of the last 30 years, when we see the geopolitical process in the last 30 years, under the guise of the Oslo process or the peace process, this was the Bantustanizations of Palestinians. So it was not, it was actually the Israeli internal compromise between the wish, less hidden or more hidden, to see Palestinians disappear, and the understanding that we cannot repeat 1948. So that's why you condense Palestinians into the enclaves by both state and bureaucratic violence and settlers' violence.
Okay.
But now those people are much more, those people who advocate for real expulsion from the whole country, they are much stronger.
Thank you.
Okay, if I can jump in very briefly.
Please.
Just a very quick comment because of the political science perspective, which I think is important. I think, you know, as with any complex trend, right, it's difficult to point at something in specific that that really causes the shift here. There are so many different factors in play here. But I think there are, first of all, based on my interviews with lawyers on the state side, they have pointed to some kind of a shift of consciousness that happened during the second intifada. So during the first intifada, yes, definitely more openness for compensation, more openness for these claims, but then with the mass numbers of casualties, so much civilian harm, suddenly there was this pause and thinking, oh, on Israel's side, this is too much. We won't be able to handle these amounts of damages and harm. And so, and I think at the same time, this shift with the Israeli public, right, as Amira mentioned, sort of less willingness, less openness to compensating the other side. And last final point, I will say, there's also other things happening, right? I mean, with the first intifada, we were still kind of in this world of, you know, in terms of the weapons used, right? So weapons that are a lot more kind of traditional, right? Traditional types of warfare, and then kind of shifting towards the use of airstrikes, right? And drones, and so many drones and so many other types of warfare that really affects the amount of casualties and civilian harm. So I think that causes a shift as well in terms of how to treat the harm that's caused.
Thank you very much, Gilad. And there was a second question, which was about the role of the international pressure or the international community. And I hesitate to ask a Palestinian about the level of solidarity shown by the international community to Palestinians, but do you want to say something, Sophie?
Yeah, I will try to tackle this issue from more positive, optimistic point of view, because yes, we all know that the pressure of the international community, which has a huge role in at least making Israel respect law, the international law, which, as Yuval said, it hasn't been awaringly and intentionally. But on the other hand, a long process of international community pressure did bring us to the current situation where we have a decision, an initial decision of the ICC in The Hague to that in February 2021, which decided that it does have jurisdiction to open a criminal investigation on war crimes committed in the occupied Palestinian territories, which includes West Bank, Gaza, and East Jerusalem, in addition to the international pressure which led last October 2022 to another decision that the UN Security Council referred to the International Court of Justice and asked it to issue an expert opinion on the consequences of the legality of the prolonged occupation. Now, yes, we of course see the vetoes that the US apply on most of the attempts to have decisions in the UN. We don't see enough pressure, but on the other hand, we are now, and I think that the proceedings before the ICC and ICJ, no matter what tangible impact they might have, but at least on a statement declarative level, they are very important, even though we still are not in the end result or in the expert opinion or in the conclusion, or even though there's still no opening of an investigation. But this itself is a declarative issue of trying to make more pressure, which I think has been very successful. And the mere fact of having the ICC and ICJ discussions and proceedings is very relevant to this, knowing that besides all the war crimes that have been committed by Israel, whether by establishing the settlement and expanding the project of the illegal settlement and all other issues, the fact that prohibiting having a blanket ban on Palestinians to submit to access courts is in itself a war crime based on the Rome Statute, because they cannot basically based on Rome Statute, they cannot prohibit access to courts in issues that are related to effective remedy. And this was one of the arguments that I argued as well before the Supreme Court. It was back then we still didn't have the ICC initial decision, because the hearing was in June 2021, and I think I might be confusing in the years. And later on came the decision to open a criminal investigation by the ICC. It hasn't been open yet, but still, we are trying to expand and make more similar arguments before the Israeli Supreme Court, which we didn't do before, about whether the Supreme Court, of how the Supreme Court will decide, will also affect the proceedings before the ICC and the ICJ. Of course, there's no doubt that the Supreme Court, this strategy or concept not to deal and discuss the mere legality and the question of legality of the mere establishment of the settlements is in itself an issue that will be discussed hopefully by as a criminal, as a war crime, and an issue that will be dealt in the criminal court. So not only the acts of the state, not only the acts of the army, but also the Supreme Court judgments will most probably be as well discussed by the ICC, because it is another public authority, it's another public branch, and it has throughout the years, not only from 1967, but because we're dealing with the occupied territory right now, but already from 1967 until to date, the Supreme Court did have a huge part, not only in reserving the occupation from the legal point of view and providing legality to acts of war crimes and violation of international law, but it also made it possible to expand this illegal project.
Thank you. Thank you very much.
Yeah, I think we have a legacy hand from Alexandros, and we have a question online, and
right.
two more in the room.
So, do you mind putting your hands up again if you have a question? Yeah. So there's 1, 2, 3, 4, and 1 online. So yes, please.
Hi, my name's Rona Mickey. I'm from Shadow World Investigations and the Corruption Tracker. There is another group that has this sort of immunity often against the kind of legal recourses that you talk about. I'm not a lawyer, but the enablers and often drivers of violence in places like this are the arms companies who use videos of the violence caused by their weapons as marketing tools. And they use it to sell and prove the efficacy of their product. And I wondered if any of you could see any legal recourse to applying this right to a remedy, as far as a remedy can be seen as financial, to the people who are making money out of what's happening. Thank you.
Thank you. So, and here at the front.
Thank you. I'm Alexandros Antonio from the University of Essex, the Essex Law School. I suppose my question is a little bit broader. I think we've heard some very interesting perspectives in terms of how the data on that very valuable tool that Chaim and his team constructed can be explained, how some of that data doesn't capture something because it's not possible to capture it, something that, some developments that we cannot gather data on, but also we heard about, historical explanations. So I wondered, coming back to the tool that sparked all this discussion, how do you envisage Chaim informing these discussions, or how do you envisage influencing policy as we move forward? And perhaps, I wonder whether this might be also an opportunity for you to address some of the concerns that were already expressed.
Okay, thank you. Yeah, over here.
Hi, Hedi Viterbo from the Law Department at Queen Mary. Again, congratulations, Chaim Gilad and the team, everyone. Just, I can see it being a useful resource in so many ways. Apologies if I say something that's been discussed. I had to go out for a couple of minutes. First of all, sovereignty means both responsibility and powers. And it's interesting that you pointed out that in relation to the Palestinian Authority, there's this kind of ambivalence. Sometimes it is the sovereign when it needs to be held to account, but other times it's not the sovereign when it's regarded as not having certain powers. Interestingly, the same mirror trend appears in the way Israel justifies or thinks of its own actions, both legally and politically. Sometimes it is the sovereign when supposedly it has certain powers legally, but other times it's not the sovereign when it's supposed to be held to account. So it's just interesting, this kind of mirror ambivalence and how selective and functional it is. Another thing, Amira, you talked about kind of being a lay woman and not being a lawyer. Sometimes it seems like the non-lawyers actually understand the law better than the lawyers because they're not captured by this kind of kind of this apparatus of falsehoods. So in a sense, maybe you have an advantage over some of us lawyers. A couple of questions. First of all, if Chaim, Gilad, maybe some of the others could comment on something that was pointed out. How does Israel-Palestine compare to other contexts, both in terms of similarities and differences? And then also, Chaim, you mentioned briefly a new bill that's being kind of passed that could potentially expand the accountability of the Palestinian Authority. Could you say a bit about that? Thank you.
Okay, and there was a question. Did you have a question, Matan? Yeah. Please.
Thank you, and congratulations to myself and you, but mostly to you. I have a few comments. I'm a PhD student at the Bartlett Development Planning Unit, and from my background, I was a military prosecutor that was very involved in these cases. So I have both sides here, and I know these cases from my past. But I have three comments I may say. One, this connection that we talked about, not a lot, but we talked about a bit, from criminal law to this torts thing that was very very in my mind all the time that I was working on this project with Chaim and Gilad. The way that sometimes, most times, the military criminal system was didn't have enough success, let's say, in investigating and prosecuting these many cases because of forensic, because of the criminal law high bar of way of to prosecute and to investigate, and many cases because of the criminal system, military system procedures that are making it very difficult to do so. And by that, I mean the difference between commanders' investigations, tahkir tzvai, and the criminal investigation and the relations between that. So this one thing that was in my mind, and the other thing was in more special dimensions. And when I was talking with one of my friends about this project just now, and said that it's going to be, there is this great event, and he told me one thing. He's a poet, so he told me, yeah, it's a disgrace to live next to this injustice. And what this mapping shows, mapping shows how is it to live next to this injustice. So you could see it visually in your eyes. You have Israelis that lives in one side, and you have this damages that are going in on the other side. So this is a more, let's say, moral thought that I have. And the other thing is that the method that was used here, the mapping, I think it's crucial to think about it. Also theoretically about discursive mapping of legal court cases into this kind of website. So trying to think about this more like in this interdisciplinary relations between spatial politics and law. I think this project is one of, I don't know a lot, but I think one of the best in this kind of effort to doing that. And
okay,
yeah, like say mapping this injustice literally in that way. Thank you.
Thank you very much. And we have a final question online, which was...
Yes, yeah. So this question is from Gidon Ginat, and it's to the panel. And he's asking, how can we proceed to a positive future soon?
Right. I think we might leave that one for the last question. Now, it's just gone 10 to 12. So we really only have time for everyone to speak once. So what I'm going to do is I'm going to divide up these questions and invite you to address a question, but also at the same time to make any final comments you have. So perhaps we can turn to Seth first. And I mean, really you're at liberty to pick a question, but also this, in particular, this quite difficult one about influencing policy and whether the law can influence policy. It is really fundamental to what we're trying to do. So,
well, it also links to the final question about the future, which I'm happy to tackle, because as a historian, we're always thinking about, is what we're doing going to help or get us out of the conundrum of the present? And one of the things that I think is significant is that you need the empirical evidence and the data to help understand the dynamics, but it doesn't necessarily tell you a way out, nor does it necessarily get read or interpreted one way or the other. And I actually want to go back in my comments to something that Gilad said about the different moments in time, or the importance of thinking about contingency here, right? That there's legal contingency, there's also political contingency of what gets noticed or what gets understood. But I think in the case of some of these legal cases, the intensity of emotions around the Second Intifada in particular, and the use of suicide bombings transformed Israeli political culture in the way in which people began to understand or think about claims as well, is my sense, not having looked at all the data specifically, but the way in which the violence, at least from the perspective of Israeli civilians, played out, led to a different conception and understanding that also fed into a dehumanizing approach towards Palestinians. Now, we could say the same in turn about how Palestinians understood Israeli military incursions and new technologies or new approaches to flattening buildings or going into urban civilian areas. So one of the things that one has to consider here is not the realm of political history or not the realm of the law, but actually how kind of emotional transformation also affected the avenues or ways in which people began to litigate or try and think their way through what was happening to them. And it, in a way, I think maybe helps me return to Yuval's opening comment about the limits of the law. And accepting the limits of the law. I'm aware, and I think, again, as a historian, of accepting that, you know, there are many different ways in which one can read or interpret the past. What I am struggling with and thinking about this as an outsider to the legal profession or to legal scholarship is what happens when a focus on the law replaces a focus on politics. And what I sense in this bigger story is that rather than thinking or considering political decision-making or outcomes that take particular political contours or identities, we instead look to the law either as an answer or either as an excuse. And that, I sense that is part of the danger that certainly a lot of civil society has pointed to, is that it reifies or it ossifies some notion of using legal recourse to resolve what at its core is political contestation. And so what I'm trying to suggest is not whether or not there aren't real benefits at the margins to people who are using the recourse of the law, but to try and get us to think outside of the trap of just a legal interpretation. So I hope that maybe helps a little bit answer what some of the questions have raised, but there's certainly a lot more to get to.
Thank you. You remain a skeptic. Thank you. Thank you, Seth. Chaim, this new bill, just tell us a little bit more about the new bill.
Yeah, so I can say very briefly about the new bill that if it passes as is, and they rarely do, the way in which it expands liability is in two ways. One, by providing easier access to the courts to really ground the reasons for why the Palestinian Authority should be held liable to compensate Israelis who were injured in hostilities. And the other way to expand liability is by simply to anchor the amounts of damages that are going to be awarded, and they're going to be far greater. So instead of 3 million shekels in punitive damages, it's going to be 5 and 10, depending on the type of injury. So we're going to see the sums expand significantly, as well as the number of claims that are going to be brought.
Thank you.
Yeah, well,
Sorsen, there was this question which, well, I mean, Martin was talking about his really interesting experiences as a military prosecutor. And of course, there have been prosecutions of IDF fighters over the years.
yeah.
Just to talk to us about the relationship between civil actions and prosecutions, and why both are important.
Accountability is one of the most important principles in international law and in any kind of violation to human rights, not only international law. States should be responsible and reliable for the violation of rights. And what is happening here, if we make a zoom out and look at the fact, based on also to get back to what I said before, is that the mere purpose for the short and long term by Israel is to give full accountability, to give no accountability basically to any acts of violation, full impunity, not only from being prosecuted before the Israeli court, but also, and most importantly, before the ICC and international court. So this impunity is being provided by law to civil procedures, like what we are talking about, but also to criminal liability, which, as you mentioned as well, and as we are seeing, is being provided to any act of soldier and any decision of any kind of person in the higher ranking in the army. Now, criminal impunity, civil impunity, these cannot be ignored. These should be seen in a more holistic view of what Israel basically wants, what Israel, especially the new, within the context of the new government, what it wants. And if we take a look, and I want to connect it here as well to what Seth was saying and what's going on the ground today in Israel, we are now confronting the 37th Israeli government, headed by the most extreme right-wing coalition, which its basic principles, as has been published, is that Jews have not only a unique, but an absolute right in all the land of Israel, in all areas. This is the basic principle that that the government refers to. And this is why most of the decisions, most of the laws, most of the policies that not only before have been designed and undertaken, but will be more strengthened from now onwards, is serving a political vision of having a state that is in all the land, historic land of Israel, in a settler, colonial, and apartheid context, where there is supremacy for the Jews, and we'll deal with the Palestinians. Their status is not clear. Their legal status, I mean, they will not have citizenship. Their legal status is not clear. Definitely they are inferior, but the criminal liability or the lack of liability and impunity for civil should be seen as one part and one anchor of the more holistic picture of where this, not only this government, but all of them, but mostly this government is heading, with, by the way, with the support of the Supreme Court.
Thank you very much. Gilad, can I ask you one thing and in particular to come back to this question about influencing policy? I mean,
yeah, absolutely.
one thing that struck me about all the team that's been working on this database and the map is how you all have experience within the system. And I know from my work at Ceasefire that often what we do, we work in some of the world's most difficult jurisdictions. But one of the ways in which we work is that we find people within the system who have a conscience, who want to do something, who believe that protecting civilians is important, it is right. And I think, is there scope for working within the system as well as internationally to try and influence policy for the better?
Yeah, it's a great question. I think, you know, it relates to this theme that Yuval and Seth sort of touched on, the relationship between law and social change, right? And whether you can create social change sort of from the inside, right? Working within the system. I think thinking about this question, especially in the current moment, you can also see sort of an arc, which is a little bit pessimistic in this current moment, right? Because you see that while in the past, you had a lot of reliance on procedural mechanisms, right? And Amira touched on that too, and Sausen in their comments. Some of the barriers to bringing claims were procedural in nature, things like entry permits and costs and things like that. For that, I think there's a lot of room for people within the system to do the right thing, right? And to be more conscious and seeing the other side and trying to make change. But as we shift towards blanket immunity, right? So laws that essentially block any possibility of bringing claims, which I think the current climate in Israel is definitely will be more receptive to those kind of claims. And we can't even count anymore on a judicial intervention because there's also this crackdown on judicial independence in Israel. My concern is that there will be less and less room for people within the system to really change anything when they're working with a system that's really stacked so much on one side rather than the other. So the balance is really being shifted in this way. Sorry to end on such a pessimistic note, but that's my reading of where things are going.
Thank you very much, Gilad. I'm going to just try and deal with a couple of the other questions that came in very quickly. You asked a really interesting question about enablers, including arms manufacturers. I think I don't know enough to be able to talk about particular cases involving Israel, but certainly I'm thinking about other countries on which we work, including, of course, Yemen and the complaint made to the International Criminal Court, which tries to look at the responsibility, the complicity for the basically Saudi coalition bombing in the Yemen war that was advanced by our partner Muatan Organization for Human Rights in Yemen. So that's really potentially very interesting, as well as jurisdiction in the Italian court on arms transfers to Yemen. Also possibly the litigation regarding Lafarge, the big chemical conglomerate in the French court and in the US courts for their actions in Syria. But I can talk to you more about that afterwards if you're interested. There was this really interesting question about, yes, how does Israel compare to others? So in 30 seconds, just take the UK, 8 years of occupation in southern Iraq, as well as Operation Helmand in Afghanistan. In that time, there were, I think, a total of 5 or 6 convictions of UK service personnel for offences against the civilian population. Only 1 case of a war crime, and that was when Baha Musa was kicked and beaten to death in a UK detention centre. 5 or 6 people were tried for that. Only 1 was convicted of dereliction of duty, a minor offence. 32 million pounds has been paid in compensation by UK authorities to civilians harmed in Iraq and Afghanistan in total. So you can see that civil claims, and there were payments in something like 6,500 cases, have been a much more effective way of delivering justice. Imperfect justice, insufficient justice, but nonetheless some justice compared to the poor state of the criminal prosecutions. And that is a pattern that is basically repeated in most war-fighting states, including in Israel. So you can draw from that comparison what you will. There remains this question about the positive future, or is there anything positive for the future? I'm not sure you're really going to. I'm not sure you're really going to
say so, yeah.
But please, yeah.
Look, we sit here and I think about the present absentees, people that, you know, I've been writing about and meeting over the years, and were affected and sort of and hope that they would see some justice. I mean, it's not really justice if you lost all your family, but to put somebody on trial. And I was in Gaza just after the first big war of 2008, 2009, and met with many of the survivors of the Israeli attacks, and met with the lawyers in Gaza who were working together with lawyers in Israel, and with Adala and others about putting to trial the people who, Israeli officers and others who caused the death of so many civilians. And one of those lawyers, Iyad El-Alami of Gaza Center for Human Rights, told me, you'll see, we won't have any success with cases of casualties, of people who are killed, but we will succeed. Israel prosecute soldiers who stole something. And it really happened. I mean, it's the first cases and the most famous cases were somebody who stole a credit card, exactly. So exactly what he said. And you know, there is Megillat Purim, how you say it, the Megillat Purim, when the Jews celebrated the victory over the assistant of the king, the anti-Semitic assistant, if I may use this anachronistic term, Haman. They celebrated, and they were reproached when they were celebrating and killing and everything. This was okay, the killing was okay, but not the stealing. You should not steal, you should not rob. It's okay about killing the out of joy or whatever, or revenge, but don't steal anything. So this it's like an old commandment that passes through to the army. Just recently, I was asked by somebody whose brother was a worker in Israel and happened to be at a morning cafe just before leaving out to work. So they were in a kind of a makeshift coffee shop at Tulkarem, and he was shot dead by soldiers and was killed when they invaded the city. So the brother asked me, is there any point at pressing charges against the state or getting indemnities for my brother's loss, because the whole family is now without a breadwinner? And I had to tell him, no chance. I mean, just don't put yourself into it. If to say anything about the future, anything positive that I can say, or a bit optimistic, is that every day, every year, I learn more about how rooted the Palestinians are in their place. I mean, it's like a cliche, but it's not a cliche. Sumud really has is a very real part of life. So this is the only thing that gives me hope for the future, that they will be able, and we together with them, to resist this dark wave of Israeli fascism. But it's going to cost a lot of suffering, first of all, on the part of Palestinians, if the outside doesn't doesn't wake up. And in this outside, I also mean Jewish communities. And maybe it's a bit of, maybe I exaggerate with my, or essentialize. Maybe I essentialize the role of Jewish communities because they are part of their class and their position in those countries. But still, if they do care for this place, they should know that fascist, complete, wholesome fascist rule is not going to benefit, certainly not the Palestinians, but also not the Jews who live in this country. That's the most positive, the most optimistic thing I could say.
Thank you so much, Amira and Susan in particular, for taking the time to come to London and to share your really compelling.
We're always
Thank you for inviting.
Thank you. Thank you
For inviting.
Thank you, Seth, for your wise words. It's been a huge pleasure working with Gilad and Chaim on this database, and we're so proud to be part of it. And thank you, Matan, and thank you, Yom, and everyone who's been part of the project. Thank you all for coming. I haven't done my job very well. It's already gone to 12:10, but there is something to eat and drink in the room next door. So please stay and join. Thank you.